Okay, this is LAWS 12065, Foundations of Property Law, and this is the last topic or the last tutorial covering the substantive topics in the course. And today we're dealing with topic 11, the Personal Property Securities Act 2009 Commonwealth, that's the PPSA, and the registration of interest in property other than land. Okay, so we've got that cleared away. Yes, no, I mean, look, I understand that it's difficult for people to attend everything, and I know that the Wednesday class. I just had to make a decision about when to offer that. I certainly wanted to cover, as I mentioned to Samuel in that class, I wanted to cover the last two topics prior to the end of week 12. And I was juggling around when I thought would be best. On the one hand, I wanted to do it in the evening because many people have indicated that's a better time slot. It had to be a time when the license was also not being otherwise used, and so that's what I settled on. But look, in the end, it has been recorded and it'll be posted later today. That's what I'm going to do, and these classes are being recorded as well for those that can't attend, and then hopefully we've got a few more coming along to the exam preparation class on a Monday. Well, just before we kick off, Lisa, is there any questions, comments you'd like to make?
What time is the exam prep class on Monday evening?
7:30 till 9 p.m.
Okay, thanks. Regarding the now, I read through the Chapter 6 registration handout you gave to us to read, and I finally got through it. Lots of highlights. I've just got a few questions, and I did the text reading, but I must admit I haven't quite finished through your notes yet. So do you want my questions now or later?
Oh, let's deal with them maybe progressively as we go. And have you had a chance to have a look at the tutorial problem or not?
Not really. Not really. I haven't done the questions. I've been busy summarising all these notes.
Sure. Yeah, that's fine. That's fine. Look, what I'll do, is I'll facilitate the discussion, obviously a bit more given just yourself here, and given the focus of the work that you've been doing with regard to the topic. And then I'll just stop at different points and ask if you've got a thought or a contribution to make on that, or something to clarify or something to add or whatever. Is that okay to proceed like that?
Sounds perfect.
Okay, good. Sort of like a quasi-seminar and sort of tutorial, which many of my classes seem to end up being anyway. But anyway, there you go. Okay, so all right, so this topic is about the PPSA. Now, as I commented in Wednesday's class, this is actually another innovation, I think, which is fair to say that I've brought into this course. A lot of other law schools, I don't think, actually have a topic on the PPSA in their foundation or the basic property law courses that students study. There might be some reference to it. Might be dealt with in a commercial law course. Some of the bigger law schools might have a whole course on it. That could be possible. But I think it's important to be dealt with in this way, particularly in the foundations course. We saw, for example, back in topic 4 that we dealt with, how property rights with respect to personal property, and we saw how the general law framework deals with that. And even then, in Chapter 4, and there's some, I've referred you to that with regard to this topic, there's a brief discussion on the PPSA, in particular the focus on the background and how it evolved and why it was thought to be necessary. And of course, the two underlying policy imperatives with regard to personal property is, on the one hand, the idea of ownership and how we guarantee the rights of the owner? On the other hand, how do we provide security? And this idea of security, of course, is precisely dealt with through the PPSA. So it seems to me very logical that we should have a discussion of it, and that's the reason I've created a topic in this way on it. It also provides a nice counterpoint, I think, to the fairly deep and robust analysis that we'll undertake of the system for the registration of interest in land under the Torrens system in land law next term, over which there is an enormous amount of law, case law, and it doesn't all sort of sit nicely together, in the sense that there's been a lot of issues about what do concepts mean, how do we understand registration in the context of land. So now we've got this framework since 2009, operative since 2012 with respect to personal property. And so I think that's the best way to do it. So that's where we're looking at that. It's a broad overview topic, of course. It's a huge area. It's a huge piece of legislation. If you had a look, as you've indicated, Lisa, to the Duggan and Brown chapter, I was able to get the publisher to convince the publisher to give me a PDF watermarked version of that I could upload onto the Moodle site for my students. But that book is an excellent book. But if you had a look at the book, you'd see that it's a fairly detailed book. I mean, it's not a great tome, but it's a fairly detailed analysis of the provisions, and that's really beyond the scope of this course. But in choosing something with a little bit more depth, I decided to choose the chapter on registration, because that's actually the critical idea here. I mean, there's others as well that relate to that, but the whole point of this is that the security interests are registered on the PPS register at the end of the day. And I've given you the hyperlink on the website under topic 11 to the new Australian Financial Security Authority, which is the government agency that administers the PPS register. You might like to just note in passing that the AFSA, AFSA, I suppose, is, Commonwealth agencies love to use acronyms. There'll probably be a lot less acronyms now after the budget, saying that 70 agencies are going to be abolished or merged with others. But the AFSA also has carriage of the area of bankruptcy. That was previously under the authority of an agency called ITSA, which was the Insolvency and Trustee Service of Australia. That's now become AFSA, and so it manages bankruptcies which relate to individuals, and it also manages and administers the PPS register and the law relating to that, which is the PPSA. So as part of our investigation here, we're looking at some of the key ideas that I note there in the introduction: registration, what is personal property, what is a security interest, the ideas of attachment, the perfection of the interest, and how do we go about enforcing that, and the idea of, again, as we looked at a little bit, we looked at in topic 6 with regard to the general law issue about competing interests. Here we're looking at priority between competing security interests, and also specific attention to PMSIs, personal money security interests, in terms of the special priority rule that's documented in the legislation there. So basically the structure of the notes and what I wanted you to focus on is they basically go through each of those concepts in building the picture about how do we understand security interests under the PPSA structure? How do we secure that type of an interest that we have over personal property? What do we mean by personal property? Is it goods? Is it more than that? Well, certainly it includes goods, but it's more than goods. It doesn't include land. It doesn't include, for example, legal and equitable liens. And it also draws distinctions between consumer property and commercial property. And that's a point that's brought out in the notes and also in the reading from Chambers. So maybe if we go to the problem question, because that will help us to structure coming back into what I believe is a key way of understanding some of what's going on here. We might also have a look at a couple of those examples that I've provided as well. So the problem question says, explain in what ways the PPSA is informed by but distinguishable from general property law rules and principles. In your answer, refer to specific concepts and sections of the PPSA as appropriate. Did you want to make a comment or raise a point or anything at this point, Lisa?
Look, I had a few questions to ask, and I might put them out there because you might want to deal with them now or during the class. The first one was that if a person was wanting to borrow money, would the lender run a search under the grantor's name and the serial number to be
Sorry, I've just lost you. You've gone on to mute again.
Be prudent? Yes, sorry, I don't know how much of that question.
No, I didn't.
If you search both registers under the grantor's name and the serial.
All right, so look, you seem to have a few connection problems. What you can do is an alternative is just use the chat box, and you can post your questions via the chat box, and then I can incorporate them into my response and my recording, seeing that you've got a few bandwidth issues this morning. That might be the best way. That first question, you might like to clarify that through putting something in the chat box. But I think the first question linked to borrowing. Look, the PPSA, it's more about, the focus is upon the security interest that the provider is getting over personal property, whatever that personal property is. Obviously, in most situations, of course, that's supported by a financing arrangement. And of course, the thing that is actually registered is not the security interest as such, but when we go back to the discussion on registration, for instance, starting on page 12 of my notes, you will see that what is actually registered is a financing statement. And the point I make there is that the PPSA is a notice registration system. Even though security rights over personal property are created by documents, under the PPSA, those documents are not registered. So the documents may give rise to the interest, but it's not that which is registered. We'll see how that's actually different, under the torrent system, for example, for land. But even then, it's not the document which creates the interest under the torrent system, but it's the registration process which gives what the torrent system provides to what, in that context, we call the registered proprietor. So the act of registration is quite important, but in the context of the PPSA, there's the emphasis on this financing statement. So you can see there again, just on page 12, that what actually happens under the PPSA is that secured creditors register a financing statement which provides notice that they may have or acquire such rights. So these financing statements, which is what's actually registered, can be in relation to something that's already taken place or can be in relation to something that will take place and hasn't been yet finalised. But the point subsequently there is that the advantage of this type of a system, which is a notice-based system, is efficiency, as it's much easier to manage and store short forms rather than maybe more complex documents that link back to the security interests that are in play. So I'm not sure, you didn't post anything in the chat box. You can find that if you don't know where that is. That's okay. We've got that. Good. So if land is exempt, does that mean that personal mortgages will not show up as a debt? What do you mean by personal mortgages? If you're referring to a mortgage with respect to land, then that's not something that's dealt with under the PPSA, because interests in land are not regulated by the PPSA. But if you, for example, were talking about a chattel mortgage over personal property, and personal property, as we know, can include any or all of, and again, this is, I think, page 13 of the notes with regard to personal property, pursuant to section 10 of the definition in the PPSA. We can be talking about goods, documents, accounts, debts, financial property, intellectual property. And if we're talking about goods, goods can include crops, wool, extracted materials, vehicles, ships, aircraft, and even satellites and other space objects. Now, it's not a lot of us that are going to be concerned about security interests with respect to satellites and other space objects. But the interesting point here is that the PPSA is not just for individuals over whom security interests have been taken with regard to items of personal property that they've acquired, but of course it is intended to govern the whole array of often complex issues of the financing of personal property in business situations. Yes, a chattel mortgage over personal property. A chattel mortgage means that, chattel being personal items of personal property other than land. So, for example, let me give you an illustration. I'll come to the attachment point just in a moment. For example, the idea of a chattel mortgage can apply with regard to a motor vehicle. And today, if a vehicle is purchased under finance, then very typically today, because of consumer credit law changes, hire purchase agreements are less likely. More likely it's a chattel mortgage, which means that the person who's acquiring the vehicle is the owner of the vehicle, and under a chattel mortgage arrangement, the financier actually takes a mortgage over the property and gets a secured interest. But that interest should be registered on the PPSA register, and that is the way that can be utilise the facility of the PPSA on the one hand, and also make other third parties aware of this security interest against this item of personal property, which is one of the underlying purposes of the PPSA. Okay. All right. So I'll deal with the attachment point. Okay. So if you go down through the notes, you'll see that there's a reference to attachment on page 15. Okay. And you'll see that attachment occurs when the secured party gives value. Now, this is referred to as the grantor. The grantor must have transferable rights in personal property, and the parties must either have made a signed written agreement or the secured party has possession or control of the property. The requirement for a written signed agreement is intended to prevent fraud. Okay, this can also relate to future property, but this idea of attachment is important as part of the security, establishing the interest of the security interest in the personal property. Reference there to section 19, which requires two conditions for a security interest to attach to an asset. One, the debtor or the grantor. The legislation talks about the grantor rather than the debtor. The grantor must have rights to the asset or power to transfer it to the creditor, and value must have been given for the security interest or do an act whereby the security interest arises. The reason for the reference to the debtor as the grantor is because it relates to the rights with respect to the personal property, not with respect to the loan. or the financing sort of behind it. So it's about the rights with respect to the property itself. And this gets back to differentiation between how financing is a part of the equation, but how we're focusing on the rights with respect to the property. Okay, so I'll get to the last point about registration shortly. With regard to common law rules, common law and equity rules, the point there is that there's a similarity between the system under the general law, but it's not exactly the same. Particularly, for example, when we look at the area of priorities under the PPSA, and there's some mention of this made in the notes, that there is similarity to the way priorities are dealt with under the general law. But the important point of difference is that there's no differentiation between legal and equitable interests under the PPSA, as of course we know there is under the general law. So it's always the case that when you're dealing with an area, and the PPSA is really no different to any other area, where legislation has come in and dealt with the topic, what very often happens is that it provides a more streamlined, a more straightforward method for doing something. It does away with some of the complexity and some of the differentiations that the general law had evolved to try and grapple with the situation. It uses often its own language. So in this case, we've seen the language of, uses attachment, security interest, what that means, personal property, what that means for the purposes of the legislation. So from a practical point of view, in terms of assessment and in this course and in terms of exam, and I've already indicated to you that this is a topic that will be covered by the exam, very important to anchor your response in the provisions of the legislation. Now, that doesn't mean quoting slabs of the legislation, not at all, but it means making appropriate reference to the critical provisions of the legislation which anchor the key concepts to show that you understand that legal framework which governs this particular topic, and you understand how that framework does it through the language and the concepts that the legislation actually uses. However, very typically what the Parliament has done is it's drawn on the experiences through the disputes that have occurred and the way in which the law has dealt with this previously. So there's often sometimes a point of correlation and a point of contrast with the way the general law dealt with these sort of matters previously. If you go back into the background discussion at the beginning of my notes, it's clear that previously it wasn't just, this area wasn't just governed by general law. There was legislation, but it was state-based legislation. The problem was that it was all a bit of a mismatch, a bit of a hodgepodge, differences in all different jurisdictions, no uniformity, no consistency. How could someone who went from state to state or from state to territory be able to understand or discover whether or not there was an interest with respect to personal property if a person who had that personal property wanted to make further borrowings in relation to that property or use that property as a security for making, getting further borrowings. So this was the problem, and there was a lot of unsatisfactory treatment of different types of property. And then when we had the further issue of potential for fraud and criminal behaviour and conduct, then the system and the arrangement that we had in place was unsatisfactory. That's where we got to the national PPSA framework. Of course, the federal government, the federal regulators, the federal administrators will always be emphasising, we need a national scheme here to provide uniformity and to provide consistency, because that's this waxing and waning debate between, on the one hand, we're a national entity, we need national regulation for everything, but we're still a federation. If you go your constitutional law state, you're still a federation, so you still have states and territories. Well, shouldn't they have control and responsibility for things? Well, certainly post the federal budget this year, it's absolutely abundantly clear that the Commonwealth has a desire to make sure the states take their responsibility for some things, and they want to sort of back out of the level of responsibility that's been accumulated over some of the years. So there's that sort of always, this tension between, should this be something that's pursued by the Commonwealth or by the federal government through federal law, or should this be left to the states? In this area, I think everyone was agreed that the system was unsatisfactory. There was a great deal of potential for fraud and for a lack of being able to actually determine what was the nature of interests held over personal property. And so there was almost like a common voice, I think, of a need for a national system. And that's how the PPSA emerged through that. I think it might be actually useful, Lisa, if you've got the website for the course open, you might like to just click on the web link for the Australian Financial Security Authority, and under just when you go to the home page there is a slideshow, and you can see various items mentioned there. But if we just waiting for one to come up, which I think might help a little bit in this regard. Okay, I'll come to perfection in a minute. Okay, so when you get to, you see the slideshow, if you click on the PPSR video, and maybe if you can click on professional advisors and the PPSR. So basically the page is, if you go to, just click on the link to Australian Financial Security Authority from the course website under topic 11. And then when that takes you to the home page, there's just a sliding screen at the home page.
So let me tell you about the
Have you found it yet? All right. Well, maybe having a little bit of difficulty there. There are 3 videos there on the as part of the explaining the basically PPSR informational videos. Yep. So you can have a look at that a bit later on if you like. 3 videos there. One deals with small business and the PPSR, which is, PPSR is the Personal Property Securities Register. So one deals with small business. Another one deals with buying a used vehicle or valuable second-hand items, which is quite good. And then the second and the last one deals with professional advisors and the PPSR, okay, and what role professional advisors can play. So I encourage all students to have a look at those short video YouTube clips, very useful, and a nice, very practical way of explaining how the PPSR operates. Just going back to your point, Lisa, about perfection. So the idea of perfection, where have I got that? So on page 17 of the notes, the idea of perfection is addressed. So basically, perfection provides a key alert as to the existence of a security interest, and there are basically 4 methods under the PPSA whereby a secured party will be able to perfect their security interest. The first of those is by registration, by register on the PPS register. The second is possession by the secured party. So secured party might have possession of the goods or of the property. We have to not just talk about goods, because the PPSA in terms of dealing with personal property, has a broader canvas than just goods. But even within goods, it's a fairly wide classification of what are goods for the purposes of the PPSA as well. The third method is control. So control by the secured party. This applies only to limited types of property such as investment instruments, bank accounts, and letters of credit. So you can see there that the PPSA applies to both tangible and intangible property, not just tangibles. And then there's this fourth way of perfecting the security interest, which is called temporary perfection. And this is a short-term statutory fiction which arises upon a change of circumstances. So basically, the legislation is providing a set of a situation where, or a mechanism whereby perfection can take place on a temporary basis if there's some change of situation that's arisen. Okay, so that idea of perfection is important because it's a part of how others are alerted to the existence of the security interest over the personal property. Yes, so the act of registering on the PPS register is one of the methods of perfecting your security interest. Okay, and that's probably one of the best ones. But there are other methods as well that allow for perfection. Yeah, the order of how it happens is, that's right. It's pretty important. Look, when you go back, the main thing is that the protection under the Act for the security interest occurs even before the security interest may actually, come into being, because again, as we emphasised at the beginning, that what you actually register is a financing statement. Okay, you're not actually registering the documents that link back to the personal property. So to use the example we looked at before, the chattel mortgage, it's not the mortgage document that is actually lodged for registration, but it's this financing statement. And because this is a notice registration system, then this can be at a time even before this has actually been finalised. Okay, so that's an important feature to bear in mind. If we just go back to the question again for a sec. Okay, we need to get to enforcement, of course, that's important, and we'll do that before we finish. So the second part of that question relates to, in your answer, refer to specific concepts and sections in the PPSA in terms of the relationship between the PPSA structure and general law. Well, there's really, and this is documented in my notes. There's a few areas where there's a bit of an overlap, if you like, or a drawing upon the general law ideas. The first of those really is that notion of going back into topic 4, NEMO-DAT, this idea of NEMO-DAT. And again, it's not that the PPSA has taken these ideas and cemented them within the PPSA structure. That's not what we're saying. What we're saying is this looks like and has correlation with these general law ideas or principles that have emerged over time, but actually the PPSA structure is a bit different. Okay, but we can look at compare and contrast, if you like, and say, all right, that's how the general law dealt with the situation. You remember, under the general law, there's the idea of NEMO-DAT, which means that the seller cannot give better title or give more than they actually have. So that, if we're talking about a thief passing on title, then they cannot do that. They cannot pass on more than they have. But as we know, under the general law, there has been exceptions to that. And also, not only under the general law, but some exceptions through legislation. And as we cast your mind back to topic 4, you remember the Sale of Goods Act and the Factors Act in Queensland, and these documented exceptions to the general NEMO-DAT principle. Okay, But we're just saying that there's some degree of correlation there between the idea of NEMO-DAT on the one hand and what's going on in the PPSA framework on the other. And you'll see, there's discussion of that back in my notes. There's also this idea of, the notice of knowledge of the security interest, and this idea of notice, which is important under the bona fide purchaser exception to NEMO-DAT, right? But the notice of knowledge of a security interest isn't relevant to how we deal with security interests under the PPSA. So there's a point of differentiation or distinction, okay? And very typically that is the case, because what's important is the order in which interests are registered, or if there's another mechanism for securing the security interest or perfecting it, as we've seen there are other types of ways of perfecting an interest, then it's how that takes place. So basically what we're trying to say here is that there are general law notions or concepts that have been helpful to better to understand how the PPSA has emerged, but they're not dealt with exactly in exactly the same way. When we get to priorities shortly, we haven't got onto priorities yet, but when we look at priorities, we'll see that again there's a bit of a similarity with the general law way of dealing with priority disputes. However, as I pointed out a bit earlier in the class, that while a general law, it's absolutely essential to draw a distinction between equitable and legal interests. And just on the side, I'll just say that a lot of people had some very interesting fun and games with question 3 in the quiz 2 with regard to deciding what sort of interests were in play there. But at the end of the day, I think hopefully most people will have agreed that actually we had equitable interests, 2 competing equitable interests. We didn't really have enough to satisfy the existence of any legal interest. And that, of course, if you made that error, then that flowed through to everything else. But, I was still happy to read what people had to say and to see whether they understood the concepts and the methodology, and I would give some reward to that. It wasn't so fatal that they got nothing subsequently and therefore almost got nothing for the question. But it is very important as an indicator, that sort of question, to characterise the nature of the interest. But it's equally important to then be able to explain the consequences of having so characterised, because you can get some reward for that even if you've made the incorrect characterisation based on your analysis of the facts or whatever. So the point here is that, looking again back at the correlation between the general law concepts and ideas and what's going on in the PPSA, in terms of priorities, there is some correlation there. However, as I mentioned earlier, the PPSA does not draw a distinction between legal and equitable interests for the purpose of determining priorities. Of course, what it does is it draws distinction between interests that have been registered under the system and interests that have not. And one of the critical ideas there, if we just pop up to the discussion of priorities, which starts at the bottom of page 17 of my notes, you basically, there's a distinction there between perfected and unperfected security interests. We've seen that there is a method for perfecting the interests and therefore alerting others to the existence of the interest in various ways. The best really is registration, but there are other methods that are available. So the contest then becomes between interests, more than one interest that's been perfected, and how do we deal with that, or between perfected and unperfected interests, okay? Or there could well be also, contest between various or more than one unperfected interest as well. And you can see just there on page 18 that according, pursuant to section 55 of the PPSA, the way in which we deal with priorities is that perfected interests take priority over unperfected interests. Priority between perfected interests depends on the order of perfection, and priority between unperfected interests depends on the order of attachment. Okay, so that takes us back to that idea of attachment that we were looking at a little bit earlier, and also perfection. So the PPSA sets out a structure for whereby these interests that are in competition with each other under the PPSA structure can actually be dealt with. Just coming back to the question again, the tutorial problem question. All right, so still looking at this priorities issue. The other one, the point, and like when you have a look at the chapter in Chambers, you'll see that there are then sort of various points made with regard to the way in which security interests can be perfected, which is a bit more of an elaboration on those methods that were described a bit earlier, you know, registration, by control, and so on and so forth. But a couple of ones that I've teased out there in the notes, which, because I think, you know, there's a bit more controversy about them and a little bit more detail that you need to be aware of, is that, so on page 19, the bottom of page 19, there's a reference to, and also the other point I just mentioned in passing, again, whenever you're dealing with any particular concepts or ideas, link back to the relevant section of the legislation. So if you're dealing with perfection, link back to what is the relevant section dealing with that. The example given there on page 19 with regard to satellites and so forth, section 21 2C. The next idea of these particular notion of purchase money security interests, where there's a special priority rule, again, that's dealt with under section 62. So if that comes up in a question that you're responding to, link back and mention and refer to that section. Not to repeat it, obviously, but to just tease out the critical bits. So that's the legal underpinning of what you have to say with regard to these areas. Okay, so you see there the discussion about the PMSI, or the PIMSI as they're referred to. There's a special priority rule available to the secured party who lends money, enabling the purchaser to obtain the collateralised item defined as a purchase money security interest. The special PMSI rule arises where a secured party specifically provides value for the purpose of acquiring collateral. And the PPSA confers a super priority on a PMSI holder where they have taken action to give notice of their interest to the other secured party. This is achieved when the PMSI holder perfects its interest in collateral by registration and meets specific notice requirements. Okay, let's go to one of the examples that I've provided because they include PMSI interests. So, for example, if we look at the simple example on page 22, a manufacturer of ovens wants to supply goods to a retailer on retention or retention of title basis. The retailer holds the goods as inventory. Prior to supply, the manufacturer searches the PPS register and discovers that a bank has a general security over all of the retailer's assets. Okay? To obtain super priority over the goods, that is the goods that the supplier is going to supply, that is the ovens, the manufacturer must send a notice to the bank and register its own interest on the PPS register. The notice must state, so there's specific requirements with regard to the notice, that the manufacturer expects to acquire a PMSI in the goods, contain a description of the goods, and set out the effect of the provision that confers super priority in accordance with section 101. The manufacturer's interest in the ovens must be registered before the retailer or whoever else this relates to obtains possession of the goods. So the registration must occur before there's a transfer of possession from the supplier to the retailer. And then if this relates to intangible property, then that must occur before there is attachment with regard to the security interest. So you can see that even though in that scenario, the bank has a general security interest floating over all of the retailer's assets, both current and future. And that also, interestingly, links to a little bit the design of one of the interests in quiz question 3, but that was in relation to land, not in relation to personal property goods. Then another entity that comes along and gives, is providing personal property as defined under the PPSA, and that's being financed in some way, or is subject to an arrangement whereby, in this case, for example, a retailer then sells the goods and part of those funds then revert back to the supplier, then they can get a priority over the goods in regard to their security interest that actually rises over the general security interest that the bank has, but only in regard to their particular goods. Under other systems, you'd probably, you'd look at this the distinction between, for example, under the Corporations Act, but this has now been impacted by the PPSA, the difference between fixed and floating charges. And if the company went into liquidation, the fixed charge holder could rank in priority to the floating charge holder, if you like, under those arrangements subject to the legislative requirements. So that last question you've got there, I don't know if I've addressed that. So are unperfected interests, not registered interests, unregistered interests? Well, I'll just go back on that point to the process of perfection. Okay. And you can perfect your interests in various ways, as we indicated before. And one of those ways is registration, but you can do it in other ways as well, okay? So the secured party will be able to perfect a security interest by one or more of 4 modes set out in the PPSA. Good, that's clear, good, okay, great. So one or more, but under the arrangements now in place, this should be emphasised, okay? It would be risky not to register your interest, okay? But you can do more than that, okay? So that's good, that's clear, good. Good, okay, so coming back to the question, problem question again, because we haven't finished with it yet. There's another area that we can link back to the general law framework, and this actually links back to something we discussed early in the course, and that is the enforceability of property rights. And how do we go about that enforcement process? Do we enforce them in rem, that is against the goods, or do we enforce them in personam, that is against the person? If we come back to the discussion about enforcement, which is starting at the bottom of page 20. Wait a minute, back. There's a discussion of enforceability a bit earlier than that as well. So enforceability, okay, so enforceability is dealt with on page 16. Yep, enforcement is at the bottom of page 24, but there's also some reference back to the process of enforceability back on page 16 that I just wanted to draw your attention to, because this is where this part really links to. So I've taken, there's a bit there from Chambers, a security interest can be enforced against the debtor once it has attached to the asset, but it cannot be enforced against third parties. So it can be enforced against the debtor, right, that's fine if it's attached, but it cannot be enforced against third parties unless the creditor also has possession or control of the asset, or the parties have made a written security agreement which was signed or adopted by the debtor, and that's pursuant to section 20. So basically, there's a distinction being drawn here between how we actually go about the enforcement process. And then I make the note, which links back to, again, a point made in Chambers, that note the implication of enforcement of property rights in rem versus in personam. That is, against the goods as opposed to against the person. All right? Now, this also links back to that discussion we had in topic 2 regarding how should we enforce rights. Well, the method of enforcement under the PPSA is specified. So when we go forward to enforcement, which you correctly point out, Lisa, is starting on page 20 and forward, to make a security interest effective against third parties, a secured party would need to ensure that it has possession or control. This is reinforcing the point made earlier. Ensure that it has possession or control of the property, or that it has complied with the requirements for written security agreements. This means that the security agreement must describe the collateral. So the security agreement must do these things so that the security interest can be enforced against third parties. It must describe the collateral. It must be evidenced in writing. It must be signed by both parties. Okay? And then the next point, which I think is also important, is that it's important to remember that the rules set out in the PPSA are in fact based on the idea that transactions are actually discoverable by third parties, because it's third parties often that want to see what is actually happening with respect to items that are now part of what personal property captures for the purposes of the PPSA. So, it's important to appreciate how the mechanics of the framework fulfills the philosophy and the purpose and the rationale for why the framework came into existence in the first place. All of those things that we've mentioned, NEMO-DAT, exceptions to NEMO-DAT, priorities, and how we go about enforcing rights, there are correlations here to the way the general law emerged in dealing with these matters with regard to personal property and the PPSA framework, but not identical. There have been changes. They're not exactly the same, but you can look at comparing and contrasting to basically work out how effective and how useful the PPSA framework is in light of how these matters were dealt with previously. One point I'd like to just highlight there for everyone is that on page 21 of the notes, there's a reference made there to something that point that Chambers makes, but it's actually a link to section 111, sub 1, which specifies that the enforcement provisions must be exercised, so this is in regard to enforcement, must be exercised or discharged honestly and in a commercially reasonable manner. Now, this hints at something that came up in an earlier class, not specifically with regard to the PPSA, but more generally. The idea of honesty, well, we can scrutinise behaviour, we can scrutinise decisions, we can scrutinise activity to work out whether a person's been honest or not. What about this idea of commercially reasonable? How do we determine what is commercially reasonable? You can put something on the chat post if you like, Lisa, if you want to respond to that. It's a good stab. Let me just bounce back. One of the tensions that was identified in one of the previous classes was that surely what the law is about and what judicial decision making is about, and surely what legal frameworks are about, therefore qua legislation, is to allow us to objectively determine what something should be or shouldn't be against a framework, rather than subjective determinations. this idea of what is commercially reasonable, is that something that we can objectively determine, or is that subject to subjective response, or how and who makes that decision? The reasonable person test, what I would call the mercurial reasonable person test. Yeah, I suppose that's fair enough. In all the circumstances, it's a good response. Very good response. Well played, man, well played. The point I suppose I'm wanting to tease out for everyone here is that, and I made this comment on the previous class and in the recording, that, look, the truth of the matter is that it's a balancing act at the end of the day. So whilst, of course, there is an objective aspect to it, and that's very important, we cannot resile, there's only way for me to describe it, we cannot resile from the fact that, for example, if this provision came up before a court to be decided in relation to how an enforcement provision was being sought to be carried out, then a determination by the court as to what was commercially reasonable in all the circumstances would be predominantly through an objective analysis, but there would also be a subjective aspect of what the judge felt was commercially reasonable as well. I'm not saying that that's overbearing the process, but I'm saying it's an aspect. And there's often a subtle interplay, a subtle relationship here between the objective and the subjective in terms of how we decide that a test that's in law, whether it be in legislation or developed through the general case law, is fulfilled at the end of the day. And where we see that the legislation itself actually enshrines these ideas that have a degree of malleability about them, then that's anticipated in the process of dispute resolution. Now, we don't have any case law on this yet because it's so recent. But in time we will, and we'll see how the court deals with some of these aspects of the arrangement as we do in all situations. All right, so that really, that for me deals with part A of question 23. If we go to part B, in relation to the PPSA, explain what is meant by the focus is clearly on function over form. Do you want to have a little go at this, Lisa? Do you want to put something on the chat forum, maybe? What are we getting at here? Focus on function over form. All right, okay, fair enough. Okay, that's fair enough. So, look, really, the point that I'm trying to tease out here is that the PPSA has been said to adopt a very functional approach to secured lending. What does that mean? It means that all personal property security interests are regulated by one law and will be treated similarly, okay? There will not be different laws for motor vehicles. There will not be different laws for commercial plant. There will be not differences between one jurisdiction and another jurisdiction. Okay, the nature of the document that specifies the interest in the property will not be the thing that differentiates the way we treat the interest, because it's not actually that document that gets registered. It's actually a financing statement that actually gets registered. So certain arrangements that give an outward appearance of ownership can also be treated as though they were security interests under the PPSA. An example might be, for instance, a lease for a limited term, and also possibly maybe something in the nature of commercial consignment. Okay, but this idea of function over form is very important as a driver of the PPSA reform structure, because often the way the law sometimes emerges as a piecemeal process over time is that form does become important. We've seen, for example, earlier in the course that for the purposes of securing a legal interest recognised under the general law, form was very important. That's actually why in question 3 of the quiz, the mortgage to FB, Fidelity Bank, was actually not a legal mortgage, because not everything that was needed to be satisfied from a common law point of view had been actually completed for the purposes of saying, yes, we had a legal mortgage. That's where scrutinisation of the facts becomes very critical. So in general law, that was, this idea of form became quite critical. We've seen throughout the course that equity often provided a response in such a way that where formality and form requirements weren't met, but it would actually be unjust or unconscionable not to recognise the existence of an interest, then equity would step in within parameters and against the principles framework that it had developed over time. Legislation often, is about doing something different, something new. And I suppose the point here is that what's being focused on, and another way of explaining function, I suppose, is also the form-substance debate. What's being focused on is the security interest and the personal property and the mechanism that the PPSA provides to allow the security interest to be recognised over personal property according to the definitions of what is a security interest and what is personal property under the legislative framework of the PPSA. And that once you meet the definitional requirements of a security interest and personal property for the purposes of the PPSA, then that's it. It draws distinctions between tangible and intangible properties, but once you've satisfied the requirements of the legislation, then it treats those interests similarly for the purposes of the protections that the PPSA framework provides. This idea of the functional approach too was to provide a more efficient system so that any interest of that kind anywhere within the boundaries of the Australian jurisdiction could be dealt with similarly, and also you could search this one federal register and you could discover the interests affecting property wherever they happen to be within the Australian jurisdiction. And clearly, this should be seen as beneficial, particularly in business and commercial transactions. But even in circumstances of individuals. So, for example, if you're living in one state or territory and you move to another state or territory, and then there's transactions involving personal goods, to see what security interests are over those goods, having gone from one part of the country to another part of the country, that's useful. And to know that there's one scheme and there's one register that you can go to know what's going on with regard to the security interests that are affecting this personal property, that's very useful. And the fact that the personal property includes a whole range of types of property and not just goods, that means it extends to a fairly broad range of types of property interests, which the previous law probably dealt with often in very different ways. So it provides a universal, consistent, and more reliable way of determining the property interests that impact upon personal property, or the security interests that impact upon personal property in the end. Good. That's really all I wanted to say, actually. I think, oh, right. Look, let me say in response to that comment, and that's a helpful comment. I'll just note for the purposes of the recording, Lisa's indicated that's a better answer than that she might have been able to provide. Look, I don't expect my students, despite their background experience or whatever, to be able to respond to the questions which I'm posing to you in the way that I necessarily would. And I do not grade them, and I do not mark your work according to what I think I could have written, okay? So that's very important. I want everyone that's listening to this recording to remember that I am grading what I'm seeing against what I expect a student doing this course, which means studying property law for the first time, could do, but meeting the expectations in terms of writing and constructing a response to either an essay question or to a problem-solving question in a way that is appropriate, and using the law, showing insight, showing perceptiveness, fashioning an argument, and using it to respond to the critical components of the question. Remember, people, that you are always responding to a particular task, to a particular question, and this is actually a simulation of what you will do out there in the world as a lawyer. As I've mentioned before, and I'll mention it again because it's useful to reiterate, no person, no client comes to you wanting a general, discussion about a concept of law or what the law is or the history of the law or whatever. They want to know how to resolve their particular problem, okay? And they want advice from you, which requires informed understanding based on law, but also professional judgment. They want to know what they can and can't do, but you need to structure that advice and that response based on what the law permits and doesn't permit. But this idea of what it permits or doesn't permit is not always black and white. There can be flexibility around this, and that's why one lawyer might advise in one way and another lawyer might advise in another way. So that's a process of methodology and mindset that your legal education is basically equipping you with. And look, this is an evolving process. This course is offered as a second-year course, and, most of you should be doing it then. And all of you will be studying in the program. It's a 3-year degree. You may be taking a bit longer than 3 years if you're doing it, part-time. But, it's an accumulation of learning, an accumulation of how to think like a lawyer and to write like a lawyer and to respond to problems and issues that lawyers have to deal with. So that's my comment there. Lisa, if I could just ask, you're the only one with us, maybe if you can, like the way I like to finish my classes, is if there are 3 takeaway points that you have got from today's class, maybe if you can think about that, jot them down and then maybe share 1 or 2 of those via the chat post, and then I can just wrap things up. Okay, so just greater understanding of the PPSA. Certainly clear because I was a bit confused, that's fine. Anyway, Chapter 6 registration, probably should have read the notes. Yep, that's fine. All that's good. Sorry, I'm just having a problem with one of my documents here. I'll deal with that later. Okay, so, basically, I suppose if I was to put down the takeaway points, that the critical process of registration, how you go about securing your security interest what are the methods of doing that, what is the type of personal property that the PPSA framework applies to, and how does the framework deal with priorities between security interests, and then the difference between those interests that have been perfected and unperfected interests, and then also this idea of the PIMSI, and how they're dealt with under the system of the framework, and then lastly, I suppose the point is what lessons are there in drawing comparisons or contrasts between the general law framework dealing with personal property and the framework that's been developed under the PPSA, and what distinctions are there? What are the lessons from the contrast, but then what are the distinctions, and be clear about the way the PPSA governs the security interests of personal property as opposed to the way the general law previously did with regard to transactions involving personal property. All right, there we go. That's today's class on topic 11, dealing with the PPSA and registration of interest in property, personal property other than land. Any last comment, Lisa, before we sign off? Oh, here we go. Does a lender have a serial number search as well as a search in the grantor's name? Well, one thing you can have a look at, for example, is you can have a look at if you go into the register, the PSR. There are various ways in which you can search. So, for instance, if you were wanting to search, say, for a motor vehicle, you search by way of the number, the VIN number of the vehicle, which is an identifier of this particular vehicle. Okay, so that's one method that's used for that type of an interest. So then there will be others for other types of interests, but you can imagine, because personal property, for the purposes of the PPSA, includes both tangible and intangible property, then this won't always be the case. But it might be for some types of personal property, but not necessarily for all types, depending on what it is. So there could be also, what's being registered as the financing statement. So some method for identifying the particular statement, which then documents the nature of the interest that is intended or is effective at the time. So it depends on the nature of the personal property is probably the best way for me to put it. All right, I'm going to sign off now, and we'll say bye for now, and good luck with everyone's continuing preparations for the final exam. And just remind everyone that there will be an exam preparation class from 7:30 till 9 p.m. on Monday, the 26th of May, and I will get the recording for topic 10 posted hopefully this afternoon, and the recording of this session will go up hopefully by Monday. Yep. Okay, bye for now. Bye, Lisa.